You know, we all hope to make things as easy as possible for our families when we're no longer around. But how do you actually do that? Well, today we're going to break down a really powerful tool that can help, the living trust. Let's get right into it.
So let's just kick things off with a really direct question. When you pass away, who is actually in control of your assets? We're talking about your house, your savings, your investments. Who gets the final say on what happens next? And you might be surprised to hear that for a lot of folks, the answer involves the legal system in a big, big way.
And that system, that process, is something called probate. It's kind of the default setting for handling someone's estate. And as you can see here, it has a reputation for being slow, pretty expensive, and maybe worst of all, very public.
Okay, so right off the bat, let's clear up a huge misconception. A lot of people think, oh, I have a will, so I don't have to worry about probate. But actually, that's not how it works. A will is really just your set of instructions for the probate court. You're still going through that formal process, where everything is basically frozen until a judge says it's okay to move forward.
Yeah, and that reputation, it's usually pretty well deserved. I mean, think about it. Whenever you get courts and lawyers involved, things can drag on for months, sometimes even years. And all of that time, all those legal fees, well, they get paid for right out of the assets you were hoping to leave behind for your family.
So what exactly gets tangled up in this probate trap? Well, it's any asset that is titled only in your name. If your name is the only one on the deed or the account, then when you pass away, those become probate assets, and they're automatically locked into that court process.
And look, we're not talking about pocket change here. This usually includes some of the most significant things you own. We're talking about your home, maybe a rental property, shares of stock, CDs, even your stake in a business. If any of these things are in your name alone, they're all headed for the probate system.
But here's the good news, not everything has to get stuck in that system. Just look at the difference here. On the left, you've got those probate assets, frozen, stuck in court. But on the right, you have non-probate assets. Think of things like your 401k or a life insurance policy. Those have beneficiaries listed right on them. They pass directly to your heirs, no court, no fuss. So the whole game really is to get as much of your stuff as possible out of that left column and over to the right.
So how do you actually do that? How do you keep your family's inheritance out of a courtroom? Well, this is where the hero of our story swoops in, the living trust.
The easiest way to think about a revocable living trust is like a special box, a legal container that you create to hold all your valuable stuff. And that word revocable, it's absolutely key. It means you're still the boss. As long as you're alive and well, you can change it, add things, take things out, or even get rid of the whole thing if you want. You have total control.
This is it. This is the magic trick. When you put an asset, like your house, into a trust, you're not the owner anymore. The trust is. And because the trust doesn't die, its assets don't have to go through probate. It's that simple, but it is incredibly powerful.
All right, so avoiding probate sounds amazing, right? But how does this thing actually work? Well, you can think of it as your own private rulebook for your assets, and it's not as complicated as it sounds. It's actually a pretty logical process.
It really breaks down into 4 simple steps. 1, you create the legal document. That's your rule book. 2, and listen, this is the step people sometimes forget, but it's crucial. You have to fund the trust. That means actually retitling your house or your bank accounts from your name into the trust name. 3, you name a successor trustee. This is the person you trust to step in and manage everything according to your rules when you're gone. And 4, when that time comes, your trustee just follows the instructions and distributes the assets to your family. No court, no judge, no public drama.
All right, so the living trust is definitely the star player here, but it can't win the game all by itself. To have a really complete, buttoned-up plan, it needs a good supporting cast of a few other documents.
First up, you've got something called a pour-over will. Just think of this as your safety net. Let's be real. Life happens. Maybe you open a new bank account or buy a car, and you forget to put it in the trust name. Well, this special will is designed to catch any of those forgotten assets and just pour them right into your trust so everything ends up in one place under your rules.
And a really solid plan doesn't just think about what happens after you're gone. It protects you while you're alive, too. That's where these come in. A durable power of attorney lets someone you trust handle your finances if you can't. A healthcare power of attorney lets them make medical decisions. And a living will clearly states your wishes about end-of-life care. When you put all these pieces together, you're covered for pretty much any curveball life might throw at you.
Okay, so we've gone through a lot, right? From the headaches of probate to the nuts and bolts of a trust.
So what's the one big idea you should walk away with? What's the why behind all of this?
It really just boils down to this one simple idea. The whole point is to shield the people you love from the stress, the delays, and the cost of a public court battle, especially during a time that's already going to be incredibly difficult for them.
And really, that leaves us with one final and maybe the most important question for you to think about. Is your own plan truly ready for the unexpected? Is it designed to make things as smooth and private as possible for your family when they'll need it most? Thanks so much for tuning in.